right. Hello, everyone. Before we begin, I'm going to ask that we take a moment to pause and reflect on some of the history that has brought us to this point and how we might individually and all together to contribute to moving forward on the path of reconciliation. This land on which the University of Toronto operates has for thousands of years been a gathering place for many Indigenous peoples across Turtle Island. It has been stewarded as a site of learning, exchange, teaching, and sharing. This has been the traditional land of the Huron-Wendat, the Haudenosaunee, and the Seneca, and I also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. Today, this meeting place is still the home to many Indigenous peoples from across Turtle Island, and we at the law school are grateful to have the opportunity to learn and work and to build community in a good way on this land. And so I'm delighted to have the opportunity to welcome everyone to what really is a highlight of the academic year, the Grand Moot. It's definitely also one of the perks of my role to get to kick off this wonderful event every year. It's a U of T law tradition, and as you all know, and that's I think partly why you're all here, 4 of the law school's most skilled mooters make their submissions to a distinguished panel of Canadian jurists. And this year's Grand Moot judges, we'll hear more about that, but it is the Honorable Justice Nicholas Kasirer from the Supreme Court of Canada, the Honorable Justice Jill Copeland from the Ontario Court of Appeal, and the Honorable Justice Andrew Pinto from the Ontario Superior Court of Justice. And our Grand Mooters, Olivia O'Connor and Julia Capellacci for the Appellant, Ben Park, and Emma Danaher and Ryan Reed for the Respondent, Flavel College. We also owe a quite considerable debt of gratitude to the Moot Court Chief Justices who stand for the moment on the sidelines, Sang-Yoon Park and Ben Grondin. You've done all of the heavy lifting really in planning for this evening, including drafting the problem, coordinating the drafting of the facta, making timely submissions to the justices, organizing the evening's events. So this is really no small feat, and here we are in large part thanks to you. I also want to recognize the generosity of McCarthy Tetro, both in terms of funding this event, but also in terms of the time devoted to it. And that entails in particular a shout out to 3 McCarthy's associates and U of T law grads and mooters, Holly Kallmeyer and Christopher Puskas, led by Liliana Stanic, who devoted a lot of time to the organization and planning of the event and assigning run-throughs and coaching mooters and a whole number of things. And then also many, many thanks to Professors Richard Stacey and Hamish Stewart, I see here, Martha Schaefer, Chris Essert, who watched run-throughs and whose feedback and thought were essential to refining both the problem but also the submissions of the mooters. And last but certainly not least, and I don't know where she's gone to, she's probably disappeared into the background, Assistant Dean Sarah Farity for the support of this event and the organization and kind of planning a long time and ahead to get dates secured and so on. And our events team led by Aviva Lev-Aviv. Again, lots of hours go behind the scenes into making things run smoothly. So that is it from me. I will now turn it over to the Chief Justices for a little bit more information.
Good evening, everyone, and thank you all for coming to this year's Grand Moot. My name is Ben Grondin, and this is Sang Park, and we've had the privilege of being the student justices for this year's Moot. We'd first like to echo Dean Brunet's comments and give a special thanks to our generous sponsor, McCarthy Tetro, whose support every year makes the Grand Moot possible. In particular, we'd like to thank Holly Kallmeyer, Chris Puskas, and Liliana Stanic from McCarthy Tetro, who were invaluable to the organization and planning of tonight's event. We would also like to thank the many members of our law school community who played a crucial role in helping us draft this year's problem. That includes the Grand Moot bench clerks, who provided invaluable research to help us prepare what we hope is a challenging and interesting problem. It also includes Dean Brunet and Assistant Dean Faraday and the many other faculty members who generously donated their time to looking over the problem or doing practice run-throughs with the mooters. Thank you all for your help and continued support. At this time, we ask that members of the audience please turn any electronic devices to silent. We also ask that you please not leave the room once the moot begins so as to not distract the mooters or the panel. And with that, I'll hand things over to Sang, who will be providing a brief overview of tonight's problem.
Right, we know everyone's looking forward to the moot, so again, just a very brief overview of the problem before turning the floor over to the mooters and our distinguished panel. The appeal that you'll hear tonight takes place in Flavel, a country that is functionally equivalent to Canada in both law and history. The problem explores the emerging relationship between artificial intelligence and the law by asking two questions. How does the use of AI impact our privacy interests? And how does the use of AI as a decision-making tool impact the fairness and reasonableness of those decisions? In the year 2026, academic institutions are threatened by the widespread use of AI for cheating. Our respondent tonight, Flavel College, decided to fight fire with fire by overhauling its proctoring and disciplinary procedures. Moving forward, all students at Flavel College are required to complete their assignments and exams using ExamTech, an AI software that records video, tracks their keystrokes, records their screens, and more. When ExamTech suspects that a student is cheating, it sends that data to Decide AI. Decide AI is another AI software that predicts whether a student has cheated, and if so, how much they should be punished. After Decide AI makes a recommendation, students get to plead their case in an oral hearing to the Dean of Academic Integrity, who, rest assured, is a human being. Our appellant today is Ben Park. Mr. Park is a former student of the college. Just 2 weeks before his graduation, he was accused of cheating by ExamTech, and Decide AI predicted that there was a 90% chance that Mr. Park did, in fact, cheat. Mr. Park got to plead his case before the dean in an oral hearing, but ultimately the dean decided to follow Decide AI's recommendations and expel Mr. Park. As a result, he was unable to graduate. Mr. Park is now challenging the college's AI policies as well as the decision to expel him. First, Mr. Park argues that the use of ExamTech to monitor students violates their constitutional right to be free from unreasonable searches. And second, Mr. Park challenges the decision to expel him by the dean as being procedurally unfair and unreasonable. We're very fortunate to be joined tonight by the Honorable Justice Nicholas Kasirer of the Supreme Court of Canada, the Honorable Justice Jill Copeland of the Court of Appeal for Ontario, and the Honorable Justice Andrew Pinto of the Ontario Superior Court of Justice. We will now cede the floor to the Grand Mooters, Julia Capellacci, Olivia O'Connor, Emma Danaher, and Ryan Reed. Round of applause, please.
Seated. Welcome everyone. Bonjour à tous. So I'll call the appeal Park against Flavel College. Ms. O'Connor, you'll be pleading first for the appellant.
Good evening, Justices. My name is Olivia O'Connor. My co-counsel is Julia Capellacci, and we represent the appellant, Mr. Ben Park. To To respond to the growing threat of artificial intelligence-assisted academic misconduct, the respondent Flavel College enacted 2 policies. Under the first, students must be monitored and recorded by an artificial intelligence software called ExamTech whenever they write an exam, which is something that we're relatively familiar with, and also whenever they draft an assignment for credit. If ExamTech flags enough instances of purportedly suspicious conduct, a second software under a second policy called Decide AI will generate a % likelihood that the student has cheated and recommend a sanction to the college's Dean of Academic Integrity. Mr. Park was monitored by ExamTech during a final exam. He was flagged and ultimately expelled based on the recommendations of Decide AI. He was 2 months away from finishing his engineering degree. The rise of artificial intelligence poses real problems for institutions like the college, and I'm certainly not up here before you to dispute that. But the college is constrained by the law of procedural fairness, reasonable decision-making, and our Constitution. I will submit to you that the ExamTech policy violates Section 8 of the Charter and cannot be upheld as a reasonable limit under Section 1. My co-counsel will then submit that the expulsion decision against Mr. Park was both procedurally unfair and unreasonable. Now, before I move into the substance of my submissions on Section 8, I want to just describe how ExamTech works. So it's an AI proctoring software that, according to the college's Code of Student Conduct, students must have open and operational whenever they work on an exam or an assignment. When students open up ExamTech, they must do a 360-degree scan of the space in which they're situated. And then for the duration of the period that ExamTech is operating, it will capture video and audio from that device. It will record the activity on a student's screen. It will track their keystrokes, and it will also keep track of their location.
Do we know from the record how long that initial 360-degree scan is?
Justice, on the record, we don't have like a precise metric for that, but it's relatively brief, temporally speaking.
And counsel, can I just ask you another question? So your position is that this is obviously unreasonable, but how do you answer the position that the student has a fair degree of control over their environment? So if they want to do a scan, they can just clear the room or at least remove it off items that may, be closer to, as you call it, the biological core or something like that. If they are moving around, they can move to a location that, knowing that this software is on. So doesn't that attenuate the sort of Section 8 problem?
Justice, there's a degree of choice here, but I think it's important not to overstate it. Many students will be in a situation where they can't meaningfully rid their space of anything in which that they would have a privacy interest. It'll depend on the circumstances, but in our submission, a fair amount of students will have to expose biographical core information. But I want to pause on a more fundamental point, which is that this court has never approached the question of whether there's a reasonable expectation of privacy. That is, whether constitutional protection attaches to a subject matter, by first asking what is left after citizens do everything in their power to minimize the intrusiveness of a state action. And the fact that we are drawn to have this conversation and we worry about what students can do in order to shield their private information from these searches, I think is indicative of the fact that there is something of importance and value that is being exposed to the eyes of the state here.
Well, Ms. O'Connor, there, for sure, but there, like, everyone in this room has written an exam before, and long before AI came into, there's a measure of indignity in subjecting oneself to an exam. And there's even this kind of latent suspicion that the school authorities seem to have, you know, placing people at their desks at distance, closed book exam, checking, making sure you don't bring your computer in some way that you'll be able. But students submit to this. They agree that they're going to have to give up some of what ordinarily might be privacy, that their expectation for privacy is diminished, maybe even at some level waived, by virtue of having the privilege of going to a college like the college in Flavel College in question here. So what's the problem? I mean, I do realize that when one dresses it up as a reasonable expectation of privacy, and we start scanning people's bedrooms, it sounds like 1984. But isn't this just a new version of an old problem?
It's an old problem, and I want to distinguish past proctoring practices that we're all familiar with from what's at issue here. So first of all, traditional proctoring typically occurs in the college's space, so it does not involve any official having a view into a student's private space, like their home. In addition,
Does the college offer any spaces for students to write exams, write essays outside of their home?
There's some spaces available, but we don't know on the record whether there is enough space for every single one of the college's 50,000 students to write an exam in the college's space at the same time. But in addition to that, ExamTech records students. And as this court held in Jarvis, the risk to privacy that attaches to recording is much higher than that which attaches to simple observation, which is what we see in the case of proctoring, traditionally speaking.
But in Jarvis, wasn't the threat, it will be recorded and then viewed by a human person, and there's much less of that. First of all, most people who submit themselves to, unless you'll correct me if I'm wrong, but as I understand it, to ExamTech, most of them, if they have less than 5 incidents, no one's going to ever see it. After a year, it will be deleted, whereas the accused in Jarvis was recording it for his own use, and so the recording was very much for the human eye, and the imposition on, or the burden on privacy was much more significant. Isn't there a difference here?
It's true that in Jarvis, the big concern was viewing by another person, but in Jarvis, the court was attuned to the features of recording and the record that recording generates, as opposed to the risk that a particular individual will then look. It's much more so about the fact that the record has been created and has the potential of being looked at. And in many cases, this record will be viewed by a human proctor or a human reviewer. If 5 instances of purportedly suspicious conduct are flagged, it will be reviewed by a human. And in Mr. Park's particular case, at least 5 of the instances that were flagged by ExamTech simply consisted in him.
Did you say many cases? Do we know how many? We don't. I wasn't
think there
sure.
were 11 instances, right?
Yeah, so there were 11 instances of
And do we know how many
flagging.
times it was used?
Well, at least more than 5 of those instances consisted in Mr. Park merely looking away from
No,
his
that I
screen.
understand, but no, but you say this happens many times, a lot of times. Presumably there are hundreds of exams administered, more than hundreds probably, and we have.
I must have misspoken, Justice.
Okay.
We don't have information
That's
on the
what I
record
thought.
about
Okay.
how many exams are being proctored by this software.
No, but you don't have that evidence. But isn't it a balancing, an appropriate balancing that, first of all, it's only after you cross the 5 threshold of suspicious instances that the AI sends the information to decide AI, I think, first of all. And then within that, you have the additional layer for human oversight. The dean, who is the ultimate decision maker, who holds an oral hearing, and I appreciate we're beyond the Section 8 part, but then holds what we'd probably much closer to a natural justice hearing to cure any defects and to sort of fill in the gaps and give the student a full defense. So what's the problem there?
So in terms of when a human will look at the information, we would emphasize that the search in question and the search that we need to be concerned about for the perspective of reasonableness under Section 8 consists in the states collecting the information through the use of the exam tech software and does not merely crystallize when a human looks at the information, because the gravamen of this court's, one of the gravamens of this court's approach to Section 8 has been this idea of control over information and control over privacy interests, and whether or not a human reviews that information, the student still loses control over it in our submission.
Your colleagues say in their factum that there's 5 incidents creates a reasonable suspicion of academic misconduct. That's when the thing kicks in. Until then, no trouble, nobody's seeing anything. The student is left to their own devices, so to speak. I'm not sure what the answer to the idea that by tailoring exam tech to a reasonable suspicion, maybe we're averting some of the dramatic problems, and I'm not saying that they're not important ones. But do they really present themselves here in the same way that you're saying in your factum?
Well, Justice, we don't know much about how the exam tech algorithm actually works. And so it would be very difficult for this court to find that the exam tech algorithm is tailored to the legal standard of reasonable suspicion, because the college has not made that information available.
Am I correct in understanding, though, that exam tech is recording whether or not it finds these instances?
Well, that's exactly true. It's recording and it is storing information, and that information exists in a record that is kept for 1 year. And then, so that information is vulnerable to all of the concerns that were canvassed in Jarvis in terms of humans reviewing and replaying and manipulating the information. I mean, we should also bear in mind that cybersecurity is always a risk. This information may not always rest with the college. So there are real risks here, even in a case where a student's information is never viewed by a human.
Can you assist me with the balancing? Because you acknowledged in your factum and in your oral submission that the college does have a pressing interest in preventing academic fraud, cheating. But there are places in your factum where you then downplay that. At paragraph 48, you say it's not on the same order as maintaining integrity at the board, or you talk about paragraph 58, a comparison to regulated industries. I would have thought it's a really pressing interest for the university in terms of balancing of an existential nature. I mean, it goes to the heart of the university's mandate. And it does seem, in fact, a university that to be a fairly regulated environment. I'm just wondering if you can help me with the balancing, even accepting that there's an important privacy interest for the students in not being videotaped.
Even accepting that there is a very significant state interest here, There are other reasons that this is not a balanced approach to the conflict between citizens' privacy interests and the state's interest in pursuing its goals through a search. For instance, this scheme evades meaningful after-the-fact judicial supervision. We don't know how exam tech works. It will be difficult for reviewing judges or even for the dean to assess whether it was appropriate for a student to be brought to the academic discipline process and whether a student ought to be found guilty, especially because of one of the ways that exam tech works, which is that it parses only the suspicious instances of conduct, and only those instances are viewed by the dean, which I'm sure my friends will argue is a method of mitigating the intrusiveness of this policy. But what it also does is it decontextualizes the record. And so it, again, will make it difficult, if not impossible, for the dean or a court on review to assess whether it was reasonable or whether it's true that a student committed academic misconduct.
Well, we may be getting ahead of ourselves, but we can anticipate that at the oral hearing there'll be an opportunity for the student to sort of say, put it into the context that you're calling for. Right now we're worried about whether it's an unreasonable search and whether it can be justified under Section 1 of the Charter. And it sounds like a lot of what we're talking about is whether it is minimally impairing, whether it's, and your colleagues say, well, yes, it is, you know, they don't, it's not the whole of the private domain, it's the scan of the room, which justified to make sure that there's no other people in the room to whisper in the ear of the candidate or what have you. And that's one of the issues actually that seems to come up on the facts in this one. Is this not minimally impairing? I mean, even if we did get to the view, we're perhaps not there yet, get to the view that there's a violation of prima facie violation of Section 8, aren't we dealing with something that's just frankly minimally impairing?
Justice, in our submission, this is not a minimally impairing scheme. The fact that this scheme could be much worse, could invade greater domains, does not suffice as evidence that the scheme is minimally impairing. Notably, the college has not adduced evidence to suggest that they have considered and rejected less impairing alternatives. Policy options such as altering their pedagogies or applying this policy only in first-year survey courses, for instance, where the risk and utility of cheating using generative AI is highest due to the general nature of the subject matter.
Putting everyone on pass-fail, giving them a star for showing up at class. I mean, you know, exams are part of life, and they come with the downside. And the downside is you expose yourself to all of it. And look how many people are in this. Imagine if we had oral exams. That would be minimally impairing. That would be a way to test everybody if they've got true personal knowledge. But college can't possibly administer oral exams to every person in the group. We're already collapsing under resourced post-secondary education. This looks like maybe a kind of a bargain, as my colleague Copeland suggested.
If the college wishes to enact a policy like the exam tech policy that is incredibly intrusive on students' Section 8 rights, that poses a high risk of exposing biographical core information, then it needs to do so in a way that is constitutionally compliant, and it needs to be able to satisfy this court that it has considered and rejected less impairing alternatives, and that no alternatives are reasonably effective at mitigating the risks of artificial intelligence-assisted academic misconduct. I've come to the end of my time, so I'm happy to answer further questions, but if not, I'll rely on my factor for the balance of my submissions. Thank you.
Thank you, Ms. O'Connor. Ms. Capellacci.
Thank you. Good evening, Justices. My name is Julia Capellacci, and I am second counsel for Mr. Park. In April 2026, after writing a critical exam, Mr. Park was notified that he had been flagged by Exam Tech and was being investigated for academic misconduct. A month later, Mr. Park was expelled, having gone through the college's new disciplinary procedure, which utilizes the second novel technology made by the college, Decide AI. And although we're in an administrative context, this is a significant decision that's going to impact and follow Mr. Park for the rest of his life. I will make two submissions today. First, the decision to expel Mr. Park was procedurally unfair, and second, it was substantively unreasonable. In turning to my procedural fairness arguments, which begin at paragraph 76 of the appellant's factum, in this case, Mr. Park's right to a fair hearing was violated because he was not given a meaningful opportunity to be heard, and his right to an impartial and independent adjudicator was violated. Mr. Park's right to be heard was violated for two reasons. He was not given a meaningful opportunity to make submissions, and his ability to make submissions was inherently limited by the lack of transparency around Decide AI.
Well, he was given an opportunity. So he filled out the form. He said he had no explanation, which I agree would be troubling if that was the end of the story. But then he gets, at an oral hearing, the opportunity to explain things. The dean is sitting there listening. Decide AI is presumably turned off. What's the problem? He can cure whatever defects came before, and in the course of that hour of hearing, he'll make his case and the dean will decide.
Well, respectfully, Justice, I would disagree that the oral hearing does cure the initial lack of submissions put forward. Now, aside from that standard form, there's no ability to make written submissions for the students. So the entirety of their submissions is in that 1 hour oral hearing. But the case for Mr. Park was especially difficult to meet here, and I want to draw this court's attention to Appendix E, the dean's decision. The fourth paragraph, the last line, after reviewing his oral hearing notes with Mr. Park, he says, "I find there's no compelling reason to depart from the findings of Decide AI."
Counsel, how is this different from courts use expert evidence all the time to be of assistance to a court? How is Decide AI particularly different from an expert who provides opinion evidence to a court, and the court, let's take the analogy of the dean, is not bound by the expert, but uses the benefit of the expertise which is developed over hundreds, and I think there's like 100,000 samples, but in a human expert developed through learning and education and expertise. So we've got a machine that's essentially done that, and we do that all the time in courts, and this is a particular academic environment where the dean would have the knowledge to sort of differentiate situations. So why is this different from using an expert, for instance?
Well, I'm glad you brought that up, Justice, and that goes a little bit to the reasonableness of the decision itself. But the reason it's different is because an expert would tell you why they think the student cheated. They would go beyond just the bare assertion that I think this student cheated. There would be reasons, and the decision maker would look at those reasons and decide for themselves whether or not they think that final conclusion by the subordinate officer is reasonable.
Didn't the dean do that here? I mean, you've pointed to one sentence at the end of paragraph 4, but we've got to look at the reasons as a whole. And if you look in the second paragraph, the dean describes the particularized conduct that was flagged by the first software and relied on by the second software.
Yes, you're right, Justice, and the reason I brought up that last line in particular is because what it shows is that Mr. Park was going to in a hearing where there was effectively a reverse onus, which meant that he had a very difficult case he needed to meet. Now, prior to the implementation of this policy,
Well, but in the first paragraph, the dean says, I am convinced on a balance of probabilities that Ben Park violated the code. He seems to have the onus correct there.
yes, Justice, but the fact that he says, I find no compelling reason to depart, indicates that he went into the hearing looking for evidence that would allow him to depart from the conclusion of Decide AI, who had said, I'm 90% sure that the student has cheated.
But the dean made that very human, very unmachine-like determination. I think Mr. Park is not telling me the truth. I mean, he said, I do not find the student to be credible in the explanations they have provided at this hearing. So here we've left the machine aside. We've got one human being listening to another and not believing it. Now, we're in a very poor position to say, we have you in front of us, we don't have Mr. Park in front of us, to say whether the dean was mistaken there on that very human calculus.
That's absolutely right, and I don't doubt and I acknowledge that the dean went through and made a credibility finding. But it's one of the legs, the report is one of the legs of the decision. It's doing work, and this, don't take it from me, take it from the college, who has said themselves that Decide AI has streamlined their hearing process. They had an entire day prior for oral hearings, and now it's down to an hour. So either Decide AI is doing some work for the decision maker, or how is it streamlining the hearing process? But fundamentally, although on the side of the college the process has been streamlined, it hasn't been streamlined for the student, who still has to make a meaningful case for why he shouldn't be expelled and why he shouldn't carry this permanent mark on his record for the rest of his life.
Just on that, I mean, we're sort of overly focused on the AI aspect of this, but if you just take the facts out, I mean, what do we have here? We have a student that takes a 10-minute break, leaves, there's conversation in the background, comes back, lots of glances elsewhere, keystrokes increase after looking elsewhere. Those are, he has no particular explanation. He has no medical record to support the explanation he gave. I mean, we're focused on the AI, but why isn't this just a reasonable decision of a dean to expel?
Because Justice Vavilov said that you can't look at a decision in piecemeal. It's true
No, I think I was doing the opposite.
Well, you're looking at the evidence without the report of Decide AI, but the report of Decide AI was part of the dean's reasoning that led him to his conclusion. So we have to look at the decision in its entirety. But to a second point, it's not just the decision that he cheated. It's the decision to expel him. And you'll notice that in coming to his conclusion to expel Mr. Park, he refers to the report of Decide AI, which said the recommended sanction was for him to be expelled. He refers to his past history of misconduct, but that's it. Despite the fact that there's a whole list of factors that Decide AI considers when evaluating what the proper sanction is. The dean doesn't refer to any case law. He doesn't explain why expulsion is proper in Mr. Park's case. So the decision to expel him also has to be reasonable. And here, if it's based on a report that contains that internal error where, for example, Mr. Park has a history of past misconduct, he could only put yes or no on the form, and that's what's considered by Decide AI. There's no additional context he can provide, and that's the report that's doing the work for the dean in deciding that it's right to expel Mr. Park in this case.
I'm sensitive, Ms. Capellacci, to what you say, and one of the things that troubles me, I'd be interested to hear from the other side on this, is that there's no internal review of this within the college.
Yeah.
So the dean is making a call, but people make mistakes. Machines perhaps fewer, I don't know, but people make mistakes, and usually this kind of process would have some kind of internal review. Is that fatal to procedural fairness here, or is, given the context, given the technical advantage that AI provides, is that internal review superfluous and we can move on directly
No,
to expulsion.
the fact that there's no internal review actually calls for a heightened duty of procedural fairness. And the lack of internal review was one thing flagged by the court in Baker as calling for a heightened duty of procedural fairness. So the fact that it's a significant decision with no ability for internal review, and I will flag that the exam policy or the disciplinary policy itself doesn't explicitly state who the burden of proof lies on. So for students who have a prediction or they're going into a hearing where it says it's 90% sure that they cheated, effectively they're going to have a very heavy case to meet, which means they should be given a meaningful opportunity beyond 1 hour oral hearing to do that. And in that 1 hour, they're supposed to defend their conduct, perhaps present evidence to the court, and also answer questions from the dean.
But one of the other Baker factors is the choice of procedures by the institution itself. And in admin law, we try to respect the choices of the institution itself. And in this case, the entire context of the AI use is to prevent a greater evil, which, as I understand it, this college's reputation was sinking because of the allegations of cheating. So in looking at the various Baker factors, why can we not say, it's a tough call here, but the institution itself has chosen, as the words say, to fight fire with fire, and it seems like a appropriate choice to me.
Well, you're right that the college does have discretion, and we're not disputing that. But all the Baker factors are to be considered in its entirety. It's not that one trumps the other. So the first Baker factor is whether or not this decision looks like a judicial process, and here it does. The second Baker factor asks us to look at the entirety of the scheme, and we've discussed that. There's lack of an internal appeal. And the third Baker factor looks at the significance of the decision. And this is an extremely significant decision. So we have three factors weighing in favor of a higher duty, and one that, okay, we acknowledge they have discretion, but even within that discretion, they're bound by the charter and they're bound by the principles of procedural fairness. Now,
Do you think Baker would be decided the same way if there had been AI in Baker? Do you think, doesn't it give us a little bit more comfort that we've got these incidents that are there to be, there's the fact-finding dimension is attenuated by the presence of AI. Doesn't it help us in?
Yes and no. Actually, if I could give this court an example of where AI was used, and it did help streamline a process, was in Hagshanah, the federal court. And they dealt with the program Chinook, which was used by the Immigration Board. And what this utilized was an AI technology that would assemble information for the decision maker. So they would go in, put the particular facts of the case, and then relevant information would be put before the decision maker. But there was no decision-making code in the AI. There was no encroaching on the territory of the final decision maker. Another good example is the case cited by the respondents in their factum, State v. Loomis, and this comes out of the Supreme Court of Wisconsin. That case dealt with the technology compass, which was used by sentencing courts to give a likelihood that an offender would reoffend. And then that prediction was used in deciding what was the proper sentence to be given. We have a very different case here. It's not as if Decide AI tells the dean, I'm this % sure likely that the student will cheat again. They're telling the dean, or they're encroaching on the dean's territory here. So a technology like that really is using AI like a decision-making tool, whereas here, the AI is encroaching on the territory of the decision maker.
How do you mean encroaching? Ultimately, the dean has the call. The dean can say, I've heard the student, I've looked at what comes out of the machine, I'm going with the student. The dean has the encroaching, I don't see it. It seems to me that the dean is completely free to make up their own mind.
2 points to that. The encroaching is because Decide AI is specifically giving a prediction on the likelihood the student cheated. That's for the dean to decide. And because they're giving a recommended sanction, that's for the dean to decide. But second point is that there are concerns of impartiality and independence here, or the lack thereof. So these are both concepts that are slightly different. It's an objective test. One is about the relationship between the parties, and the other asks whether there's an external force acting on the decision maker, pressuring them to decide a particular way. And the test is the same. We ask whether there's a reasonable apprehension of.
But does the evidence here support the conclusion that the dean is being pressured, or that a reasonable person would think the dean was being pressured by the software when he or she follows it 71% of the time?
Well, you're right that 71% of the time the dean adopts the sanction. Whenever the prediction is over 90%, like in Mr. Park's case, the dean always sides with the report of Decide AI. But further to your point...
Wouldn't that be because the evidence is more compelling? Presumably there's more instances of things that look suspicious?
Well, Justice, the important part is that for this test, we don't need evidence of bias. It's a reasonable apprehension of bias. So for independence, the Federal Court of Appeal dealt with this in Kozak. And in that case, they found there was a lack of independence, although there was no specific evidence that pointed to there being a lack of independence in the decision-making. In that case, the Immigration and Refugee Board was dealing with an influx of Hungarian Roma claims, and the board was concerned about ensuring consistency across their decision-making. So they implemented a lead case strategy, and this is what the Kozak claimants participated in. However, there was also evidence that the board thought too many claims were receiving positive outcomes. The college is in a similar position. They've developed a technology because they want increased consistency, and that's a legitimate objective. But they've also said that they think too many students are getting away with TALK GBP-related offenses. The college has also been approached by other institutions to license the technology. They're known as a vanguard of technology, and it solidifies their reputation in the community if this technology is successful. Taken all together, a reasonable person looking at the circumstances would believe that the dean would feel an external force or an external pressure to decide in line with the reports of Decide AI so that the program itself is successful.
But isn't there a tension between your and your colleague's position, and isn't there a tension, in fact, between Exam AI and Decide AI? Because if we strip off the Decide AI recommendation, wouldn't it make more sense to have all the information generated by Exam AI given to a human decision maker? So I let's say I buy your part of the argument, which is that the making an ultimate decision by Decide AI, there's something problematic about it. But if we strip off the entire program altogether and we even lose the benefits of Exam AI, we don't have an expert, we don't have the monitoring, we just back to human beings, trying to invigilate, which is hugely problematic. So in a sense, I'm saying many of the points you made are actually in favor of Exam AI. They may not be necessarily in favor of Decide AI.
Perhaps, Justice, but we would submit that really what this goes to is the fact or the issue of having Decide AI make predictions or give a report that encroaches on the territory of the final decision maker. That's really what the problem is here. So there's also concerns, though, about Decide AI itself and its impartiality. And I'll just be brief, I'm mindful of my time. Decide AI, for students who have a sanction or a GPA below 2.7, are 150% more likely to be given a more extreme or harsh sanction. Now, Mr. Park is one of those students. He has a GPA of 2.1. The sanction here, as I said before, or the dean's decision in sanctioning Mr. Park came heavily from the report of Decide AI. And it's true, Decide AI is not the final decision maker. It's akin to a subordinate officer, but like in Baker, where the subordinate officer's reasoning is the bulk of the final decision maker's reasoning, and where that subordinate officer has bias in their decision, that bias carries through to the final decision.
Is the record sufficient to conclude that because Decide AI is more likely to recommend expulsion for students with lower GPAs, that that's necessarily a product of bias? I mean, in the sense that we don't have the rest of the picture. What if in those cases there's more evidence of cheating, more suspicious indicators?
You're absolutely right, Justice. There is a difference, but for Decide AI, it won't matter, because even if the majority of cases, let's say, legitimately, there just happens to be more students who have harsh sanctions who have lower GPA, for Decide AI, the way that it makes its recommendation, it's going to look across that and think that there's an association. So you can have bias in AI, both because there's actual bias in the original test cases, or because the test cases contain a skewed average.
Do we know that on the record here? I understand the argument you're making, and I would imagine a record where you might have that evidence. Do we know that here?
What we do know, Justice, is that Decide AI looks at all the factors it considers for sanctioning and comes up with one weighted average. So if that weighted average is weighted in favor of a student with a low GPA having a more harsh sanction, then each time, even if the entire average over the course of all the decisions it's given fairly, that student will have a higher chance of being given a more extreme sanction. And I see I'm out of my time, so that concludes the applicant's submissions. Thank you.
Thank you so much.
Thank you.
Ms. Danaher, you're next for the respondent.
Justices, may I proceed?
Yes.
Good evening, Justices. My name is Emma Danaher, and I'm joined today with my co-counsel Ryan Reed, and we appear on behalf of the respondent, Flavel College. Justices, we seek that this honorable court dismiss the appeal and allow both the Exam Tech and Decide AI policies to remain valid and enforce in their full effect. And additionally, we ask that this court allow the decision against Mr. Park to stand. Justices, to that end, there are 4 submissions we will be presenting before the court today. First, that Exam Tech does not breach Section 8 of the Charter. And second, even if this court finds that Section 8 is infringed, Exam Tech is a justifiable policy and therefore saved under Section 1. My co-counsel will address our final 2 submissions. First, that Decide AI and the decision against Mr. Park are procedurally fair. And finally, that both Decide AI and the decision against Mr. Park are reasonable, as it allows for consistent and coherent decisions. Justices, this case is fundamentally about how AI has turned education on its head. Justices, with AI misconduct being unchecked, students would functionally be able to cheat their way to degrees. And the evidence shows that students were more likely to fail their professional licensing exams, and they were less likely to find employment, and then they were less likely to succeed in that employment.
Cheating is bad, Ms. Danaher. We know that already. Like scanning someone's apartment, taking pictures of the photos they have on their shelf of their mother, the books that they read on their shelves that has nothing to do with the exam they're sitting. That's not an affront to privacy. That's I'm all with you. Cheating is bad, but you're crushing a problem with by creating a bigger problem. At least that's what the judge of the divisional court seemed to say.
Well, Justices, at the outset, students at no time are forced to write their final submissions for credit or their exams within their home. And Justices, what makes AI less intrusive than a human proctor? Because as you were discussing with my friend, we know that sending submissions for credit or writing an exam is a highly regulated activity. And it's highly regulated because we put our faith in educational institutions to ensure that their graduates can enter the field and perform their duties in high quality as possible. But Justices, AI, when it's proctoring a student, is unable to meticulously review any of the information in the background. AI is trained situationally on cues that go to reasonable suspicion that there's been academic misconduct.
So Mr. Park has a copy of George Orwell's 1984 on his shelf. The dean sees that and says, "This guy's not believable. He's against technology."
Well, Justice, when the dean or any human observer, and under the Exam Tech policy, the only human observer who's ever going to view the record captured by Exam Tech will be the dean. At that point, the dean has reasonable suspicion that a student has broken a school rule.
But the recording's happening in the absence of reasonable suspicion. A student's sitting down to write their exam or assignment, and they're being recorded. And I'm wondering if you can help me. You put a lot of stress on the fact that it's going into a computer initially and no human being is looking at it. we're looking at a normative test, what Canadians think is reasonable. I'm not sure it would give a lot of comfort to most people to think, well, they're recording me while I do this activity, but it's just going to be saved on this computer. That makes me feel better.
Well, Justice, at the outset, we can't forget that any search that exam tech engages in happens in the administrative context. And the Supreme Court in McKinley Transport has held that when an individual engages in a highly regulated activity, they can expect that administrative officials are going to check for compliance. And that's exactly what's happening here. Students are engaging in a highly regulated activity, and they know from the outset that the college is going to be using exam tech to ensure that students are compliant with the college's code of conduct.
But I mean, it's a normative test, so isn't the question to ask, should there be surveillance on, for instance, assignment writing? Because in my mind, I sort of differentiate an exam, which seems like an exceptional end of year type of scenario, to assignments, and we don't, on the record, have all the information about how many assignments there are, but back in my day, an assignment could be a number of assignments that you hand in. And I'm thinking, you know, we don't know the circumstances of the student, but they are required as part of their conduct with the school to have the software on from the time that they are putting on the assignment. And I'm assuming it would be an offense to then turn it off to do something else and then come back, because that will trigger this suspicion. So we have to accept that this is the software is running just for an assignment, however whatsoever defined. That does not seem to me like something that ought to be so perhaps regulated, but so heavily regulated, and it's sort of cold comfort to just call it administrative. Sure it is, but is that the society that we want to live in? Is that the society that students want to live in, that they're just trying to get their assignments done and that they're monitored? That's the real concern, isn't it?
Well, Justice, let me clarify exactly how exam tech works. So although exam tech is used for assignments, the only time that a student must operationalize exam tech is when they're at the final stage of their assignment process and they're drafting the final submissions that they're going to be submitting for credit. So exam tech is not operationalized at all times during an assignment phase.
Sorry, is that how students do assignments in the real world? I mean, I would have...
They just do it once.
It's not, it's sort of the old days when you do it by hand and then you type it up. Presumably they're thinking and drafting and all at the same time and revising on the computer. I'm questioning whether you can isolate the typing it up period the way that you're suggesting.
Well, Justice, although this does lessen the temporal limits that exam tech is operationalized, exam tech was also situationally trained on 100,000 test cases on the difference between open book and closed book. So exam tech needs a higher threshold.
Took the computer 100,000 cases to distinguish between open and closed book? And you're arguing for us to have confidence? No, I'm sorry.
Well, Justice, to build off of that concern, we do know that exam tech is reliable as well. In the lower court, it was found that exam tech is reliable and able to deliver its functionality. And also we know that exam tech is able to pinpoint behavioral cues of misconduct accurately 90% of the time. And even in the criminal context where privacy interests are heightened, the Supreme Court in Kang Brown found that 92% accuracy in a search mechanism was reliable enough to ground the lower constitutional record of reasonable suspicion. So it lowered the grounds there.
Right,
so
but the sniffer dogs weren't sniffing everybody in the bus station. They were only allowed, based on the Supreme Court's ruling, to sniff people about whom there was reasonable suspicion. Is that really analogous to the situation here where 100% of students are being recorded when they're doing their exams and assignments?
Well, Justice, there is a need in the administrative context to ensure that regulatory schemes are enforced properly. And in McKinley Transport, the court held that random spot checks or leaving it up to the people under the control of the regime to live up to the rules may not always be effective. And here we know that traditional means for detecting academic misconduct applied to the new and emerging threat of AI failed 90% of the time. So the college here has a high interest in ensuring that all students are compliant with the college's code of conduct and to maintain a high level of academic integrity. Because the consequences of allowing AI misconduct to run rampant cut against the core object of Flavel College, which is to ensure that students had a meaningful educational and vocational training.
You've caught the vibe of the panel that were on the Section 8 were a little worried about it. Maybe you should move to Section 1 and explain to us why this is a proportional response. Why your colleagues on the other side say this is corrosive in society to suspect people, as Justice Copeland says, to suspect them before you have any reason to suspect them. Almost everybody's guilty in advance. And again, we're with you on cheating, but isn't the social cost here greater than the marginal benefit of catching the Mr. Parks, assuming Mr. Parks did something wrong?
Well, Justice, I'll address some of the safeguards that are built into the very design of exam tech. So we know that exam tech is not going to share any of the record with a human observer unless there is a triggering event. And that triggering event is the 5 behavioral cues of academic misconduct or 1 textual cue of academic misconduct. And then, and only then, will the dean view the flagged, pinpointed pieces of the record or information that go to the reasonable suspicion of academic misconduct. And when AI is running, it is less intrusive than a human proctor because AI is unable to meticulously review or zoom in on details and draw inferences about a student. Exam tech is trained to only identify what it was taught to do, which is to identify the behavioral cues that are reasonably linked and suspected to go to academic misconduct.
But counsel, how can this entire scheme survive what we know from Vavilov, which is justification, the JIT test, right? Like including transparency. So given that the AI is a black box, how can, just from a methodological point of view, this entire scheme survive transparency of the reasons? Because ultimately we have no reasons from the AI.
Well, Justice, I'll focus in on exam tech and how exam tech allows for meaningful after-the-fact review. In the administrative context, the Supreme Court in Goodwin held that in order for an individual to have some sort of adequate after-the-fact review, they need to be able to push back on and view the search or seizure mechanism, and again, push back on any associated consequences. And here, when a student has been flagged for academic misconduct, the student is provided with the pinpointed pieces of information that exam tech flagged as going to academic misconduct. So the student is provided with accurate snapshots and armed with the exact record and the fruits of exam tech's search that it used.
Your friends have raised the point that, and correct me if I'm not understanding the record correctly, that the snapshots are decontextualized, that they're not given the entire recording. First of all, is that correct factually?
Yes, Justice.
There's no access as a matter of disclosure in the process to the full recording?
In the normal course, the student would be given only the pinpointed pieces of information that were flagged.
Can you assist me with that in terms of a decision-making process? Because it seems problematic. You're looking at, it's routine in our courts in criminal matters, family matters, anything like that, that when a trier of fact is assessing what happened, assessing credibility, that they have to look at evidence in context. Can you help me with that?
Well, Justice, here the student has the accurate record, and they have the factual record of what exam tech used and the fruits of its search. And then the student has the opportunity to make oral submissions in front of the dean. And during that time, they can not only push back and challenge on the actual mechanisms and the fruits of the search, but they can also push back on any associated consequence. So a student does have the opportunity for adequate.
It's not the same as having a recording. I mean, what if before he looked over away from the camera, if you had the video before and after, you'd see that his dog ran into the room and ran behind him?
Well, Justice, the students are able to provide that context. They are given an opportunity in the drop-down menu and at their oral hearing to provide that context directly to the dean and to fill in those gaps. But this is also what makes exam tech less intrusive, because at no point is the dean or any human observer given the entire record to meticulously review or watch at will. It is only ever the flagged pieces of information that will be viewed by one and only one human observer, which is the dean.
I didn't see dog in the drop-down menu, but I'll take your word for it.
Well, Justice, they will have an opportunity in front of the dean to explain what happened and to meaningfully push back and challenge on what exam tech captured and any associated consequence. And they have the opportunity to do so in an oral hearing. And Justices, another point that makes exam tech inherently less invasive and less intrusive is that exam tech is carefully trained to only identify behaviors that go to academic misconduct. And we know that exam tech is reliable and it's able to deliver this functionality. And exam tech is also carefully designed to ensure that it does not treat the student's device as one mere physical object. The Court of Appeal in Jones cautioned against any state actor viewing a computer or a device as one mere physical object and using that as a license to essentially run rampant and indiscriminately search an individual's device.
But you're so confident in exam tech. Why do you need the dean? Why don't we just have the machine do it? Well, it's dispense of just about everything. You know, it gets 7 incidents and he'd get an email saying you're expelled. Maybe, I mean, if you're so sure that this is an infallible process, why are we having the charade of a hearing at all?
The rubber stamp of a dean.
Well, Justice, the hearing is meaningful and it does allow the student to push back on these consequences. And
push back against an infallible machine. Like, this is the point your colleagues were making about bias. Like, there's no way to make an argument. It's like pushing back against a very big rock. You can't move it.
Well, Justice, we know that exam tech is reliable, but we also know that it's not perfect, but it does deliver its functionality in a reliable way. And students here, it is not a black box. They are given precisely what exam tech used to come to the conclusion that it should flag that behavior. Students are given an accurate snapshot to review, and so is the dean. So it's not a black box. Then the students are armed with the fruits of the search in a way that they weren't in Goodwin, and they're able to use that to push back on the finding that there was academic misconduct, and also to push back on any associated consequence in a meaningful way.
So it's 90%. That's your number? Yeah. So I look out over the room here, and it's over 100 people. There are 10 people who are going to be expelled from the law school of the University of Toronto for no good reason. Like, that seems, I don't know if I'm ready to pay that cost.
Well, Justice, the 90% goes to the ability to accurately get the behaviors right as actually being academic misconduct. And again, it doesn't stop here. Students have an opportunity in front of the dean to use the accurate results that exam tech used. They have the exact record, exactly how it is, to go in front of the dean and to say, this wasn't academic misconduct.
I shouldn't have personalized it to U of T. I see the dean sitting here, who's the font of justice, so I wouldn't have any concerns about the University of Toronto. I guess it's Flavel College I should worry about.
And Justices, we also know that exam tech is designed to be non-intrusive because of the fact that it does not search a student's entire device indiscriminately. Exam tech has careful limits. It is not searching through the folders.
So can you help us a little bit with the balance, either conceptualizing it as whether the search is reasonable under Section 8 or under Section 1? I mean, one of the points your friends make, yes, it's an administrative context, but it's not protecting Canada's border, Flavel's border, from heroin being brought across the border. Yes, cheating's bad, but does it justify this, videotaping students in their bedrooms?
Yes, Justice. I don't want to overstate this, but exam tech goes to the very heart of the public's confidence and faith in education systems. The public puts its faith in colleges like Flavel College to ensure that students have adequate skills so that when they enter the field and they start performing or delivering services for the public, they're going to do so with integrity. If we have engineers who cheated their way through their program out in the world, this is not only going to erode the meaning that society places on credentials, but it could also pose a grave threat to public safety. If we have individuals in these meaningful careers who aren't armed
Counsel,
with the skills.
I think you've convinced us on the perhaps the scale of the problem and what we're up against. But one of the problems I'm really finding with the whole scheme is, doesn't it kind of incorporate propensity reasoning? And by that, I mean one part of what the AI, I think the decide AI is doing, is that it is, in a sense, penalizing the student for having a past misconduct. Now, in criminal law, we're very careful to separate out what we're focusing on. I mean, has the person committed this offense, no matter what they've done in the past? Now, when it comes to sentencing, perhaps we'll look at their past record, but the dean is, my understanding, subject to being corrected, is that the dean is receiving information and a recommendation from Decide AI that incorporates a past misconduct. And it seems to me it's more likely the person is going to receive a stronger sanction, not for this offense, but for their past misconduct. Simplified, that would, in my view, not be allowed, at least in criminal law, and not allowed in most professional discipline environments. So why is that allowed? Why is that okay?
Justices, I see that I've reached my time, so if I might have a brief moment just to respond to this question. Justices, this is simply not the criminal context. Here, an individual's liberty interest is not engaged. And in the administrative context, one of the reasons that there is a lower expectation of privacy, as set out in McKinley Transport, is because there are no draconian criminal law sanctions that are going to be imposed. And when it comes to whether or not an individual has engaged in academic misconduct, it is relevant, and it would be a relevant factor if they have a past history of academic misconduct.
Tell that to someone who's kicked out of law school.
Okay, Justices, I'll yield the podium to my co-counsel.
It's fine, thank you.
Good evening, Justices. My name is Ryan Reed, and I join my colleague, Ms. Danaher, as counsel for the respondent. Today, I will address the decisions affecting Mr. Ben Park. For the second time in 3 years, Mr. Park was flagged for suspicious conduct on a final exam. His explanations were not credible. Because of this, he was expelled. Mr. Park argues that the presence of artificial intelligence software, Decide AI, taints the decision-making process and the ultimate conclusion to such a degree as to warrant judicial intervention. We disagree. In my time today, I will make 2 submissions that together support the position that decisions rendered against Mr. Park are compliant with the principles of administrative law. First, because Mr. Park made his submissions in an open and fulsome hearing for an independent and impartial decision maker, his process was procedurally fair. And second, because neither of the decisions rendered against Mr. Park suffer from a fatal reasoning flaw, they are reasonable under the framework articulated by the Supreme Court in Vavilov.
Does it have to be fatal? Doesn't it just have to be, depending on what standard, unreasonable or incorrect, but let's say the lower standard, doesn't it just have to be unreasonable?
That's correct, Justice. But in our submission, the flaws, of which there are none that are sufficiently central to the decision, do not rise to the level to undermine justifiability, intelligibility, and transparency.
Can I ask you one thing that sort of bugged me from the start when I was reading the dean's reasons for expelling Mr. Park? His second reason was the student did not appear apologetic or contrite, nor did they admit to any wrongdoing or misconduct. Mr. Park came before the dean, impartial apparently, and said, I didn't do it. If he had been apologetic or contrite or admitted to wrongdoing, we would be not, I mean, that strikes me as completely unreasonable. He says, as one of his reasons for expelling Mr. Park. I mean, isn't that just a black hole in the decision?
No, Justice, and that's because we need to read these reasons as a whole. And with respect to the specific decision to expel Mr. Park, first of all, it comes after the dean's assessment of the evidence at issue, the specific explanations of Mr. Park, and the finding that Mr. Park was not credible.
But you'd agree that this is an inappropriate reason to expel him. So you're saying it's a péché mignon, it's a small thing that's not a big deal. When you read the whole thing, we can ignore it. But it is a problem. You'd acknowledge that it's a problem. To say that he's guilty because he didn't admit that he was guilty, this strikes me as a bit of a strange path of reasoning.
Justice, we would acknowledge that it is an unfortunate inclusion in Dean Grondin's reasons. But
where does unfortunate fit in the Vavilov standard of review?
It is not perfect. I will acknowledge that Dean Grondin is not Tolstoy, nor is he Dostoevsky. But perfection here is not required. Reasonableness is what is required. And Dean Grondin, after assessing the evidence and making his findings, first points to the student's history of academic misconduct. This is Ben Park's second instance in 3 years where he has to come before the decision maker and answer for suspicious conduct on a final exam. That is the first and the primary reason, in conjunction with Dean Grondin's assessment of the evidence, for expulsion.
Sorry, but isn't coming before that is his credibility findings? Would you agree in paragraph 3, the various findings of credibility he makes rejecting the explanation?
That's correct.
I have a concern, I'm wondering if you can help me, with the juxtaposition that the dean makes between the fact that Mr. Park gave no explanation on the form, and then he says now the student submits that their absence from the frame was as a result of a panic attack, etc. And I ask the question in the context of the initial response that the student's entitled to give by email, I think it is, to the Decide AI software or by app, where the student's effectively told, you can give us a response in writing, but it has to be one of these 8 responses. How is that a fair opportunity to respond? And then it's used against him in his credibility because his first response was lacking.
With respect to Mr. Park, Justice, Mr. Park says he has a panic attack. And on this form that Decide AI provides to the students, there are options for distraction or discomfort or for a medical emergency. In our submission, either of those would have been perfectly reasonable explanations for the student.
But maybe he didn't interpret it that way. I mean, the difficulty I have with it is the other option is no explanation, as opposed to it would be very easy to have a box that says other, in case the student went through, as Mr. Park appears to have done, and said, I don't fit in any of these 8 boxes they're offering me.
Justice, what we're concerned with here is not whether the process was perfect for Mr. Park, but whether it was fair and assessed under the particular institutional constraints that act on the college in this specific scenario. In 2026 in Flabel, where we have pervasive academic misconduct driven by artificial intelligence, where the college was failing to achieve its mandate in any significant way of meaningfully educating its students, the college made a choice to limit, in some sense, the written submissions that the students can make at first instance. But they preserved the crucial procedural aspect of a 1-hour oral hearing before the dean. In many of these cases, and in the case of Mr. Park, the central issue is the credibility of the student. That is best an explanation going to credibility is best offered in person, where you can stand before someone and say, this is what I did, or this is what I did not do, and that person can make that decision face to face.
But isn't the student's credibility shot from the moment they walk into the room with the dean, because you've got a silent witness, which is Decide AI flagging this person as a problem? I mean, by definition, I previously called it an expert witness. I'm calling it a silent witness now, is essentially saying this person is presumptively a cheater, and I am virtually, as my colleague Justice Kasirer said, virtually infallible. And by the way, go ahead now, assess this credibility. It seems like a very difficult proposition for a student to come into a room with the dean of I think engineering here, or Flavel, and make a pitch when their credibility is already shot, and it's happening because of the AI system.
Justice, we would reject the proposition that the student's credibility is shot prior to entering that hearing with the dean in all instances, and in the instance of Mr. Park. Because, again, Mr. Park had a choice. Given 5 days, he chose no explanation. But it was still available to Mr. Park to walk into that door and say, I have excellent evidence that provide meaningful and compelling explanations for what really went on in that room. And the dean has the raw audio or video footage available to him at the hearing as well. If the audio or video were flagged improperly, if there is a perfectly reasonable explanation, the dean can view that with his own eyes or hear it with his own ears, and with the benefit of his own judgment and professional expertise, can assess that in his ultimate conclusion before the student.
Mr. Reed, what's your answer to the dissenting judge in the Court of Appeal below when Beltran J.A. wrote, the dean, while the ultimate decision maker, is not considering the evidence anew. Instead of revisiting the recommendations of Decide AI, he is using them as an aid to make his final decisions. As such, the dean is not only incapable of remedying any procedural defects, but is also biased by preconceptions of guilt and sanction in the Decide AI report. Where's the mistake in that reasoning?
2 responses, Justice. The first is that it's our position that there is no procedural defect at first instance that needs to be cured. The process here is a little unorthodox. It limits written submissions in a manner that is perhaps not visible in other areas of the law or in the jurisprudence, but it preserves, as I've said before, the crux of the procedures in an oral hearing. And the second is that in McNamara, where we considered, the Ontario Court of Appeal considered the issue of a de novo review, we take a functional and a practical approach to that assessment. And we ask, in the words of Justice Abella as she then was, what is really going on here? And what is really going on here is that the dean, of course, enters this hearing with a recommendation from software, but they also enter that hearing with, again, the raw audio and video footage, with the explanations of the student at first instance, and again, in their professional judgment and expertise, can weigh that accordingly and render a decision. On the issue of bias in particular, what we're concerned with here is, again, a reasonable and practical approach. What would a reasonable person conclude here? Would they conclude that this decision maker could not decide fairly? And here, there's no evidence of any personal or professional or pecuniary interest on behalf of the dean. It's a carrot and stick situation, Justice, where the carrot is absent or replaced by a less savory vegetable.
Can I make just one small correction? You said Justice Abella as she then was. Given that she has an office upstairs and she might be watching this recording, Justice Abella as she still is. Because aren't we in the Justice Abella moot courtroom? So let's get that one right, sorry.
You're absolutely right, Justice. And if the court reporter could please have my apology on the record, I would appreciate that. Thank you very much. But those submissions on bias also work in conjunction with these submissions that I'd like to put before the court on independence, because my friends also suggested that the dean is constrained by a lack of freedom of choice here. But again, independence is assessed from the perspective of a reasonable person, viewing the matter realistically and practically, and their conclusions. And what we're concerned with in independence is the absence of improper forces acting on a decision maker. It's not any exogenous force at all. As the Federal Court of Appeal reasoned in Bovell in Canada, the mere presence of influence is not inherently problematic as long as the ultimate decision remains that of the decision maker. And that is the conclusion that the majority of the Falconer Court of Appeal came to.
But isn't that the problem with the independence? That it would be one thing if we knew that you've correctly said that we've got to look into whether the influence is what's the nature of it. Just having the influence is not a problem, but it's impenetrable, and that's the independence problem, that the AI is constraining the independent. It's a heavy force in this decision-making process, and it's also impenetrable. So it's not easy to say whether it's a negative force or not, because had we known what's inside the black box and it's penetrable and it's transparent, we can say yes, that's justified. We can live with that influence. But you're asking us to sort of accept a black box that is having an influence on decision making in an important area in these students' lives, and you're sort of asking us to take it on faith. And I think, isn't that the independence problem there?
Two responses, Justice. The first with respect to the software itself. The elements that go into the software's recommendation are a matter of public record. They're available to the students. And so it isn't a purely black box where we don't understand what goes in at all and we don't understand what comes out. The second response is that the dean, I would agree with you, Justice, if the dean's reasoning evinced a greater reliance on the recommendation of Decide AI, but that simply isn't the record before the court. We have 3 full paragraphs of the dean's individualized assessment, responsive to the particularized pieces of evidence, weighing the questions he asked of Mr. Park and Mr. Park's specific responses. Before we get to this sentence, I find this report to be highly persuasive, and there is no compelling reason to depart from Decide AI's suggestion. That sentence is statutorily required. The dean is required under the Colleges Act to consider the report of Decide AI. But it only comes after he's done the work himself. And so in our submission, Justice, a dean that is statutorily required to both consider Decide AI and to promote the academic integrity of the institution as a whole will necessarily possess an interest in finding instances of academic misconduct, but that does not undermine the independence.
The evidence about the specific subset of cases, which Mr. Park is in that group, that when Decide AI determines that it's over a 90% likelihood that the student committed academic misconduct, the dean has never made a decision contrary to Decide AI?
Justice, again, in this case, if the dean were relying on the recommendation or report to the extent of treating it as infallible, I would agree that would be an issue with respect to Mr. Park. But once again, the reasons don't evince that complete adherence.
I guess what I'm putting to you is, what, if anything, can we or should we draw from the numbers, right? I mean, in effect, you're here saying these programs are reliable. It's okay for the university to rely on the numbers. What should we do about the numbers? That, yeah, the dean knows he has to write reasons, and that, they've got to have some kind of justification or there'll be a problem. They're the dean of a law school. They're capable of coming up with some kind of justification. But the numbers show that the dean isn't making an independent decision in the cases where there's over a 90% finding coming out of Decide AI. What are we supposed to do with that?
Well, there are two different decisions at issue here, Justice. And the dean's reliance, where the dean doesn't depart from Decide AI, is relevant to the initial finding of cheating. But where the dean considers sanctions, the dean instead departs roughly 30% of the time from the software. And the notion of a lack of independence is undercut by that point, because the only place that the dean played a role in the development of the software is with respect to the factors relevant to sanctioning. That was his involvement in the development. And if that's the place where his involvement occurred, and he's departing more often there, it's our submission there that would signal that he is free to make his own decisions, and does make his own decisions based on the.
But couldn't that be
facts
then?
before him.
Couldn't that logic be turned on its head? Which is, you're saying the sign of the independence is the degree to which the dean is not relying on AI. So when I say turned on its head, what we're looking at is a situation where there's great surveillance of students, but then in a sense, it comes back to the traditional system where the dean is not actually, in your submission, relying on it as heavily. So why would we have a system which has the worst of both scenarios, where you've got the surveillance, but you're not, in a sense, you're just back to the traditional system? So doesn't that undercut the entire efficacy of the AI concept?
No, Justice. In our submission, we get the best of both worlds. And that's because we have here a software that is proven as reliable and as effective, especially in the evidence gathering situation. So once we get before the dean, we can trust in the vast majority of cases that the evidence captured is accurate and reliable. And then once we get before the dean, we again have situations that are perhaps clear-cut, and where it really reduces the burden on the dean to have a full day hearing, or canvass 20 years worth of disciplinary proceedings prior to arrive at his assessment.
Mr. Reed, I share Justice Pinto's and Justice Copeland's worry about numbers, and I'm wondering what you've got to say about the argument that your colleagues make. Decide AI itself contains biases against students with GPAs below 2.7 in a history of academic misconduct, such as Mr. Park, because these students seem to have qualities that are 1.5 or 2 times more likely to receive higher sanctions in disciplinary decisions. What's the relevance of someone having lower grades to a propensity to cheat?
Justice, I recognize that I've reached the end of my
I'll
time.
give you the time to answer that one.
Thank you. The first response, Justice, is that, once again, the lower courts have accepted, and my friends the appellants don't challenge, the reliability and efficacy of the tool itself. If we can acknowledge and accept that the outputs it produces are reliable in the vast majority of cases, it's our submission that the inputs are therefore reliable as well. But second, it's not the case that Mr. Park's low GPA was at all relevant to the ultimate conclusion reached by the dean in this case. No reference to Mr. Park's GPA appears at any point in these reasons, both with respect to whether it was likely that he cheated and with respect to the final sanction levied against Mr. Park. And in the interest of not taking up anybody else's time, or any more time, I'll leave my submissions there and ask that this court dismiss this appeal. Thank you.
Well, thank you very much. Now, I'm not sure if we're supposed to deliberate or let Decide AI do the work. Are we supposed to retire? Yes. Okay, we will retire. Thank you. Well, it was great to hear that great burst of applause as we left the room, and I had to tell my colleagues, I don't think it was for us. So well done, everybody. We're going to each have modest comments to make. I think that's part of the shtick. And so Justice Pinto will begin.
Well, thank you very much. So I must say that sitting up here, it was a very enjoyable experience, and that's part of effective advocacy, to really not only respond substantively to the material, but to have a genuine communication with the bench. And so I wrote down a couple of points, far less about Exam AI and Decide AI, but much more about your wonderful advocacy, and all of you passed with flying colors. And here's some of the points that made it effective for me. So first of all is just a mastery of the actual material. So you effortlessly referred to facts, you had your facts correct, you did not misrepresent. And another technique that I thought went very well is that when we pointed you to a problem, a small problem, you went big and said, but look at the overall, depending on which side you were, look at the overall situation. Isn't this better? And when we criticized a large problem, you went small and you said, well, look at this section of it. And that's bobbing and weaving is what makes good advocacy. Another really important point that I think all of us judges really don't like is when you don't answer the question, and all of you did. So the technique is to answer the question directly. It may be a different question than you wanted to answer. It may come out of sequence than where you thought you were in the argument, but you all did that very well. But you also managed to then return to the main stream, even though we took you out into a tributary, you returned to the main river of the argument. You also, I think, effectively used humor, and you used real life situations, because as much as we love to talk about the law and administrative law and Vavilov, what we really wanted, what this case is about, is real life. I mean, it's about the very human problem of students and institutions and technology. And in terms of some of my questions, I tried to do that, and I think you elicited a response that was embedded in the facts of real life and not in the ivory tower of the law. So I'll stop there. You did a great job, and I really feel very honored to participate, and thank you for inviting me.
So now Justice Copeland.
Thank you. So I did this moot in 1991, and nobody's allowed to do the math to calculate back to that. But I know from that how hard all of you worked on this in terms of preparing the written materials, in terms of doing run-throughs, and it really showed tonight in the oral advocacy. I agree with all of the comments that Justice Pinto made, and I'm actually going to focus on the written advocacy because I don't think it gets talked about enough in mooting. The factums that you wrote they're really of the highest caliber, and I'm not just saying that because we're at a moot and I'm supposed to say nice things. I mean, I read a lot of factums sitting on the Court of Appeal, and they are excellent factums in terms of dealing with the record, how the record relates to the legal principles, dealing with case law, and that as a building block for the oral submissions you made today. It provides a really strong foundation. And I think, although I'm not as close to the Legal Academy as everyone in this room, my impression is that students get more direct training on legal writing now than they did when I was a law student, on point first writing, things like that. And it really shows in these factums. They were really excellent. So in saying that, it's not that I didn't think your oral advocacy was excellent. It was too, but I really was impressed by the factums.
Good. Let me start by saying how grateful the three of us are to the Faculty of Law for the invitation to participate in the Grand Moot. and to thank Dean Brunet and the volunteers who've worked so hard on mounting this superb event. I'm not a U of T grad, and I certainly didn't do the Grand Moot, but I do recognize that as a McGill grad, that the Grand Moot is a major glamour moment in for student advocacy in Canada, and this was a superb Grand Moot, so well done. I start with a confession. I was a university professor for many years. Before an accident of legal history put me on the bench, and I am unburdened by experience as a litigation lawyer. I pleaded in my short and unspectacular career as a lawyer one motion. It was uncontested, and I lost. I will say it was a travesty of justice, but we don't have time to go into that. But I have been a judge appellate court judge for about 15 years, and recognize what I saw this evening as, I think we all are in agreement, superb advocacy on all four of your accounts. And you all do something that I couldn't have done, and which is plead without notes. I mean, did you see that? These people were pleading without notes. I was like, where's their notes? They were going, and we were hyperactive as a bench. I think that's fair to say. And no one was rattled. No one was fazed. So you're all naturals, and you did your university proud tonight. And thank you very much for a lovely evening.
Well, thank you all for joining us for this year's Grand Moot. We hope you all enjoyed tonight's event as much as we and our four incredible mooters enjoyed preparing for it. At this time, we would like to more formally recognize members of the law school and legal community who made significant contributions to this year's Grand Moot. So first, thank you Professors Essert, Sue, Stewart, and Schaefer, and a very special thanks to Professor Richard Stacey, as well as the Honorable Justice Lauren Sawson of the Court of Appeal. To all of you, your guidance was instrumental in crafting a challenging problem, refining the mooters' submissions, and preparing them for tonight's very insightful panel. Thank you for taking the time to help make tonight a success. We'd also like to thank each of the mooters for working so incredibly hard over the last few months to prepare tonight. The amount of work that goes on behind the scenes to tackle the novel issues as they did tonight is truly staggering. And all of that work is done with the purpose of making the Grand Moot an entertaining and impressive showcase of the oral advocacy that U of T has to offer, which is of the highest caliber, as you saw here tonight. And so, thank you to all of you. Of course, this event would not have been the success that it was without the informed and thought-provoking questions from the members of our panel. So we'd like to extend a heartfelt thank you to Justices Kasirer, Copeland, and Pinto for taking the time out of your busy schedules to be here with us this evening. Our law school community is incredibly fortunate to have you joining us for the marquee event showcasing our commitment to oral advocacy. So please accept these gifts as a small token of our appreciation. And finally, thank you once more to our generous sponsor, McCarthy Tetro. McCarthy's continued support for this event is what enables it to happen every year. We're immensely grateful that they've chosen to dedicate their time and resources to the Grand Moot once again this year. And we'd like to invite Glynis Burt from McCarthy Tetro to say a few words before concluding for the night and seeing you all at the reception. Thank you.
thank you. I could not agree more. It was tremendous. McCarthy Tatro has sponsored this event for a very long time, and I would hazard to say longer than I've been in practice, and that's a not inconsiderable period of time. And that's consistent with the long line of advocates who have practiced at our firm, prime among them being J.J. Robinette, Doug Laidlaw, and as I used to call him before he was elevated to the bench, Ian Binney. It's not too surprising then that with that proud history, we have sponsored the Grand Moot for as long as we have. And just to re-emphasize the point, you, the mooters, should be extremely proud. And part of what I wanted to emphasize through this is it is part of the Fine advocacy program at the university, and works as a teaching event, if you will. So it's not lost on me that there are, I have no doubt, students in the audience tonight who are in their first year, who are watching you with amazement, but also I think some trepidation about, I think I'm supposed to do one of these moot things while I'm at law school. And what I would say to you is, I hope you've listened well and take into consideration from tonight's event some skills that you can take away with you. But also, I think to also echo one of the comments from here, essentially get into it, relish it, and embrace it, because that's also how you succeed. So with all of that being said, I want to thank everyone who's been involved in organizing the event. I want to also thank the guest judges, and then of course finally to you, a hearty congratulations on a job extremely well done. Congratulations.
That's a wrap, folks. We'll see everyone at the reception.